Why AI regulation is necessary. The normative configuration of algorithms and their impact on legal systems. I am Francisco Balaguer Callejón from the University of Granada, Spain. My contribution will be based on my methodology for analyzing artificial intelligence under the concept of the constitution of the algorithm. This approach is based on the study of the transformation that are changing legal culture and legal systems using artificial intelligence. This methodological approach focuses on algorithms for a fundamental reason. Of the two elements that make up artificial intelligence, data and algorithm, the latter have a normative configuration, which makes them especially interesting to be analyzed from a legal perspective. To explain why the regulation of artificial intelligence is necessary, I will begin by analyzing the impact of algorithms on legal systems from the perspective that algorithms replace processes, which is particularly relevant in the legal field. This ability to replace processes is key to understanding the scope of the algorithmic revolution in all areas of life, including the legal sphere. Indeed, the increasingly popular use of AI in digital society is leading to situations in which the algorithm is occupying areas of personal relationships, political spaces, and legal proceedings where the procedural dimension was as important as, or even more important than, the substantive aspect. When the algorithm replaces the process, everything that the process contributes to these areas disappears and is replaced by mathematical procedures. The dimensions of time, which allow processes to be internalized or mature, and space, which enables participation or argumentation and is now reduced or excluded by algorithm, come to the forefront. This highlights the difficulties of harmonization that some activities or areas may face when incorporating algorithm in AI. However, this does not mean that we cannot find ways to harmonize technological development with the principles upon which our societies are founded. We must adopt this perspective, as we cannot renounce the advantages of technological development. But to find solutions to these problems, we must first analyze and articulate them. I would like to explore the importance of algorithms from a legal perspective, particularly in the context of the social transformation occurring due to the use of AI, which are opening a new period in the history of humanity. This issue is closely related to the normative configuration of algorithms and their ability to regulate our lives, communication processes, and social relationships in general. We will also explore this quality of algorithm from two perspectives here. Firstly, at an internal level, in relation to the sources of law in legal systems, there is a need to reconsider traditional categories such as the distinction between public and private law. Secondly, at the global level, we will discuss the issue of AI regulation. This debate reflects an erroneous perception of the meaning of regulation, ignoring the fact that the algorithm is already a form of regulation. Therefore, the debate is not about regulating or deregulating, because regulation already exists and is inherent to AI in many of its applications. To understand the scale of the changes resulting from AI development, it is helpful to differentiate between transformations that lead to transitions and those that lead to ruptures. Transitions act as a bridge between the past and the future. We can envisage the future in its essential features. Transitions allow us to anticipate changes and visualize their outcome with varying degrees of accuracy. On the other hand, ruptures have a different meaning to transitions. There is insufficient information to estimate the scale of the changes, but it is reasonable to assume that they will be highly significant. We cannot know the outcome because ruptures are not like bridges. They bring us somewhere we could never have imagined. Ruptures are characteristics of processes with a historical dimension that will only fully materialize over the years, defining a new social, economic, political, and legal order. To understand the difference between a transition and a rupture, imagine a door that we must pass through. In transitions, we have a greater or lesser idea of what lies behind the door. It is predictable to some extent, and while we do not know its exact configuration, we can venture a guess because we can see some light and recognize the basic features of the figures behind the door. However, in ruptures, we do not know what will be behind the door. We can barely see any light. We simply do not know the path we will follow or where it will lead. This is even more difficult in the case of ruptures generated by AI due to the dynamism of technological development. As we approach the door, the little light we see keeps changing. A classic example of a rupture is the one in Europe that gave rise to the modern world through the French Revolution. However, for legal scholars, there is an essential difference between that rupture, which occurred more than 200 years ago, and the current one. All revolutions challenge existing norms and attempt to replace them. In the case of the French Revolution, this replacement was achieved through legal norms, through law, because it was necessary to eliminate the system of custom and privilege that hindered the creation of national markets and were an obstacle to economic development. In the digital revolution, however, the market is global, and national regulations are perceived as an obstacle to economic development. The difference between these two historical situations are significant and extend to the instrument, the levers of revolution. In the French Revolution, the lever was legal, the law, through the force of law, la force de loi. In the digital revolution, the lever is technological, the algorithm. The algorithm occupies an essential place in digital society as an instrument for shaping the new reality that spans through the physical and virtual worlds. Data is processed through algorithms to order reality. Some algorithms have formally a normative configuration and operate within the framework of legal sources because they are involved in public decision-making processes. In these cases, it is necessary to consider the constitutional dimension of algorithm in relation to the system of legal sources and the need to preserve the fundamental principles of the legal order. Are algorithms a new source of law? To answer this question, we will first need to define when we are dealing with a source of law that incorporates norms into the legal system. An operative distinction is, in this respect, that of the Alessandro Pisoluso. Legal norms are those that have erga omnes effect, affecting everyone, even if they are not general or abstract. Conversely, acts with inter partes effects lack this normative condition. Therefore, we must rule out the possibility that contracts are sources of law, even though such a condition makes sense in the Kelsenian system. In principle, they cannot be considered a source of law because its effects are limited to the parties that sign them. Therefore, the legal framework of the algorithm designed within the scope of that contract, even though they affect millions of people, will also fall outside the realm of regulation as sources of law. Nevertheless, we can ignore that these companies generate their own sphere of influence, albeit virtual, in the form of a kind of ecosystem, in which billions of people move daily, operating under the conditions defined in those contracts. This digital world is a world governed by algorithm. However, the world of algorithm is not currently a place for jurists, as the digital world is inspired by principles that differ significantly from those that have shaped our legal culture until now. The way in which technology companies process data illustrates how legal culture functions within the physical world, in the sphere of state and public law, and in the realm of digital reality, because the point of reference is completely different. The question that arises is whether the distinction between public and private law can be maintained, and whether the organization of the digital society will continue to take place within the private law framework, prioritizing the economic interests of technology companies over public interest. The debate about whether artificial intelligence should be regulated, and if so, to what extent, is largely based on a false premise, because AI is already regulated by algorithm. Indeed, these algorithms have a normative configuration and are currently shaping digital society. Therefore, the regulation already exists. When an algorithm establishes that certain content has priority over others, excludes content from a social network, or establish any other form of ordering communication processes, it is performing a normative function. It is regulatory function that is currently shaping digital society. Therefore, the question we must ask ourselves is not whether AI is regulated or not, because regulation already exists in the very configuration of AI. What we must ask ourselves is who regulates AI. Here we can see how large technology companies are orienting the debate to exclude public regulation, to establish absolute dominance through private regulation. This is clearly seen in the pressure that the European Union is currently suffering under to not regulate or to simplify existing regulation by reducing its ambitions on the basis that excessive regulation can harm the development of AI in Europe. This is another fallacy, as AI was not developed in Europe before regulation existed either, so the absence of regulation does not seem to have served that purpose. Regulating artificial intelligence requires not only a willingness to subject private regulation, as represented by algorithm, to the public interest, but also a sufficient large market to guarantee the effectiveness of this regulation against tech companies. This raises the problem that national states cannot guarantee the effectiveness of their regulations, except for countries like Brazil with a market of more than 200 million people. This is why European regulation of AI is so important for Europeans, as it cannot be replaced by national regulation. However, the question in Europe and elsewhere is whether AI will serve the public interest or only the economic interests of large tech companies. The regulation of AI is a critical challenge for jurists in our century. The digital society that we are all building must be compatible with public interest, and this requires the regulation of algorithms through legal instruments that establish the conditions under which they can operate and reduce the risk and damages that they can cause.